Welcome to Employment Law This Week. I'm George Whipple. We've passed first compliance deadlines for both the OSHA ETS for employers with 100-plus employees and the CMS vaccine mandate for most healthcare workers. But courts have stayed both regulations nationwide, pending further review. In addition, a district court in Kentucky enjoined President Biden's executive order mandating vaccines for federal contractor employees, and other legal challenges are ongoing. This is a time of uncertainty for employers, but many are crafting policies to prepare for these regulations. Epstein, Becker Green's Denise Dadika tells us more about HIPAA and other COVID-19 policy considerations for employers.
In general, HIPAA does not apply to COVID-19 testing and vaccination information. HIPAA applies to specific covered entities such as healthcare providers and health plans. Earlier this year, the U.S. Department of Health and Human Services issued guidance to clarify that the HIPAA privacy rule doesn't apply to employment records, and it does not prohibit employers from requesting or retaining information about an employee's vaccination status or their COVID-19 testing records. Employers should be aware of the EEOC guidance that provides that information about vaccination status as well as COVID-19 testing results and symptoms is considered medical information that must be treated confidentially and stored separately from the personnel file. It's also important to know that only those individuals who have a business reason to know should have access to such information. There are a number of state laws that predate the COVID-19 pandemic that require employers to pay for medical tests that are in connection with employment. The state laws vary in terms of scope, with some of them applying only to applicants and others applying to both applicants and current employees. In addition, there are a handful of states that recently passed legislation to specifically address the cost of COVID-19 testing. California, Florida, Minnesota, and Utah either have issued legislation or guidance that says the employer is responsible for any COVID-19 testing that it requires. Conversely, Arkansas recently passed legislation that provides that either the government or an insurance provider must pay for the cost of COVID-19 testing in connection with employment. And if neither of those sources are available for payment, then the employee is responsible to pay for the cost of testing. So it's very important for employers to be mindful of the various laws, check with the laws in the states where the employees work, because we expect to see some additional legislation passed in this area as it relates to responsibility for COVID-19 testing. Our current understanding is that President Biden's plan is that private insurance companies will be responsible for reimbursing its members for the cost of at-home rapid tests. Most of the at-home rapid tests are self-administered and self-read, which are not permitted under the OSHA ETS unless that administration is observed either by the employer or a designated telehealth proctor. In addition, we're also hearing from insurance companies that they are not going to be paying for testing that is mandated by the employer. As of now, it does not appear that the president's plan will address the cost of testing in connection with the OSHA ETS.
Thanks, Denise, and thank you for watching. We'll see you next time.